Thank you all for being here today. We are here to make announcements that we all think are very exciting about policies that either have been in place in the DA's office during the last year, and only now are we seeing the positive results, or policies that are newly being announced today. We have a distinguished group of speakers and guests who are here with us. I'd like to introduce them quickly. First of all, we have Bree and Lily, who are both members of Juveniles for Justice, which is a juvenile law center project, and will describe their own experiences having been in juvenile placement through the Philadelphia court system. We have Councilwoman Helen Ginn, who has been a champion of issues involving education and children her entire career, including in a prior life when she wore an activist hat, which she still wears, on City Council. We also have Marcia Levick, who is the Chief Legal Officer and co-founder of the highly respected Philadelphia Juvenile Law Center. She's one of the leading experts in the nation on juvenile justice and youth justice issues. We have First Assistant District Attorney Robert Listenby, who, for those of you who may not recall, was Barack Obama's pick to essentially to be the Chief of Juvenile Justice for the United States of America at the Office of Juvenile Justice and Delinquency Prevention in the Department of Justice under Barack Obama. We have Ebony Wortham, who is supervisor of our juvenile unit at the Philadelphia DAO, Helen Park, assistant supervisor of our juvenile court unit, and we have Dana Bazelon, who is a policy advisor here in the office and took a central role in the research and the drafting of these policies that we will announce today. We also have some extremely important partners who have come here from the Defender Association, as well as some other organizations, and I will briefly introduce them, even though they may not be speaking today. We have Ellen Sapper, Leola Hardy, and Christina Bradley from the Defender Association of Philadelphia. We have Josh Glenn and Sarah Morris from the Youth Art and Self-Empowerment Project and team. We have also Isis Mederi from the Public Defender's Office, and we have our community partners who include PCCY, the Philadelphia Student Union, Youth United for Change, Education Law Center, Attic Youth Center, that's ATTIC, Philadelphia Youth Partnership, Big Brothers, Big Sisters, and the Youth Placement Task Force. Thank you all for joining us. The more detailed comments on this policy will be offered by First Assistant Listenby, one of the two truly excellent First Assistants with whom we are blessed here in the Philadelphia DAO, but there are a couple of highlights that I would like to mention, and then he can delve into them in greater detail. There have been improvements in the Philadelphia juvenile justice system for some time. In 2001, there were 10,000 petitions in juvenile court, and what that means is a criminal complaint. There were 10,000 criminal complaints in juvenile court. They are now down to 2,400. That is approximately a 75% reduction. That improvement has been going on a bit at a time for a long time, since Kevin Bethel and others, Kevin Bethel having been highly placed in the Philadelphia Police Department as a police officer, recognized that what was going on was truly a school-to-prison pipeline, and that the court system was being used for matters that often had previously been dealt with in discipline within the school system. And there was a legion of people who led that movement. What we are seeing now, and I know that Councilwoman Ginn will go to this point, is that we are no longer incarcerating youth as a first step. What we are seeing now, and I know that Marcia Levick will address this point, is that we have a partnership of people on the prosecutorial side and then in the community and also at the Defender Association to find a better way. And I think what you will also hear, and this is a point mentioned to me by Ebony Wortham, but it will be reflected in the comments of others, is that the purpose here is to address the needs of youth while keeping the community safe, and that this is not an either or. This is not a choice between the two. The one feeds the other. And that is what is so special and so important about juvenile justice, because you are dealing with a group of people who are, as the U.S. Supreme Court has said, more capable of rehabilitation and less culpable. And they are, in fact, the future of our safety, and they are in fact the future of our city. So the investment is worth it. Let me give you a couple numbers that I think highlight what some of these changes look like in concrete terms, And then, of course, Mr. Listenby will get into it in more detail. Councilwoman, it's wonderful to see you. We have Councilwoman Blackwell with us here as well.
Thank you.
The number of juveniles in placement in 2013 was 976. In 2018, it is 516. If we compare the old administration to the new administration, if we look at 2017 versus 2018, we find that it is a reduction, and this is slightly rough because it was done end of September rather than year end, but it's a reduction from 604 to 516, almost 100. In fact, it is 88 specifically. When you realize that the price tag on placement of a juvenile is astronomical, and we would approximate it at being about $175,000 a year. Having 88 fewer people in placement has the potential to make available $15,400,000 that can be used for things that are much more effective in rehabilitation and much more effective in achieving our safety. So these are not small numbers we're talking about, nor are they small achievements. If we look at another measure of how things have changed, we see that at the beginning of 2018, if you went up to State Road and went to one of the adult prisons where they have a unit for juveniles being housed in adult custody, you would find 43 young people there, boys and girls total. Today there are 10, and there are no girls who are housed in adult custody. As Mr. Listenby will explain later, even the feds have caught up with this, and there is new federal legislation that will make it nationally illegal to have juveniles housed in adult custody, but we in Philadelphia would rather lead than follow. So we're trying to get there sooner rather than later. If we look at another measure, which is certifications, and what a certification means, it's an effort in the juvenile system to take a juvenile accused of a crime in the juvenile system and move that case to adult court, which used to be all the rage when we were in the era of phrases like super predators and wolf packs. If you look at that, we see that the number of certifications that were attempted was about 10 to 12. In the prior administration, it's now about 2 to 3. So we see a very substantial reduction there. Our current juvenile justice system is failing our most vulnerable children. Today, we are here to try to begin to fix it by announcing a series of new policies that will address the individual needs of children who appear in our juvenile courts. This is the first of several steps that we will be taking to improve our juvenile justice system, and I'd like to emphasize from the start that we are only one of many stakeholders that have deep concern for our children and a role to play in improving their systems of care. The men and women of City Council, the public defenders, family court, and the Department of Human Services and community leaders and program professionals care deeply about what happens in our juvenile courts, and they now have a willing partner in the Philadelphia District Attorney's Office. There has been considerable progress over the last decade in Philadelphia's juvenile justice system. Nevertheless, it continues to fail our most vulnerable children, and that fails all of us. The policies set forth here seek to shrink the footprint of Philadelphia's juvenile justice system by decreasing the number of youth sent to juvenile placement and limiting the use of unnecessary supervision. By almost every metric, juvenile crime is down across the country and in Pennsylvania. And yet children who have been labeled delinquent for nonviolent, relatively minor offenses are often trapped in a system that fails to offer them the assistance they need and then sends them away from home when they fail. The vast majority of children in the juvenile justice system have not committed serious violent crimes. Those children are actually charged and initially, at least, prosecuted in adult court. The children that these policies seek to help are those who have committed misdemeanor or low-level felony offenses and who are sent to placement or supervised for long periods of time for behavioral problems that could be equally or better treated outside the justice system and closer to home. Examples of these offenses include offenses related to substance abuse disorders, mental health disorders, and special education needs and issues. The statistics bear out this alarming truth. 72% of the children we send to juvenile placement are sent because they are not complying with their probation, not because they committed another crime. They stay in the system often for many years and are sent away from their homes for failing to go to school, failing to make their curfew, and using marijuana. Research suggests that sending youth to placement not only fails to reduce crime, but it may actually increase the likelihood that they will stay involved in criminal activity. And these findings are not different than what we find with adults who are supervised for periods in excess of 3 years. We find they do worse, that those excessive periods of probation and parole actually cause crime. They do not merely fail to prevent it, they cause it. Purpose of the Juvenile Act of Pennsylvania is to provide children who have been adjudicated delinquent with, quote, supervision, care, and rehabilitation to enable children to become responsible and productive members of the community. In reality, the system has become overly punitive, and we are not doing enough to care for and educate our most vulnerable children. Philadelphia has the highest rate of juvenile placement of any jurisdiction in the state. Our city accounts for a little more than 12% of Pennsylvania's population, but 28.3% of the children in placement come from Philadelphia. Our city sends 2.5 times the number of children to out-of-home placement as Allegheny County, the next most populated county, and 5 times as many as Delaware County, which is the 3rd most populated county. The juvenile justice system does a poor job of addressing the educational needs of our children. In a recent study conducted in 2013, only 36% of Philadelphia children who passed through the juvenile system graduated from high school. And let's remember what we're paying for that kinds of education. We're paying over $150,000 a year per juvenile for a non-custodial placement. We're paying over $200,000 a year for a custodial placement, and that is the quality of education that we are getting. We are sending our children to facilities all over the state of variable quality where their educational needs go unmet. A child in public school in Philadelphia costs the government approximately $14,700 per year, which, by the way, is not enough. The average cost of placement in Pennsylvania, as I mentioned, is about $150,000, unless it's secure, and then it's about $200,000 per child per year. Children who are being placed on juvenile probation are often being over-supervised. They are frequently compelled to complete 5, 6, or more conditions in order to be taken off probation, despite research that recommends the number of conditions a child must abide by should be limited to 3, because it works better, because the results are more successful. Also, we cannot ignore the disparate impact that our policies are having on children of color in our communities. 73% of all children adjudicated delinquent in Philadelphia are African American, and only 0.6% are Caucasian. 71.4% of all of the children held in secure detention from Philadelphia are African American, while 5.6% are Caucasian, and nearly 18% are Hispanic. In Pennsylvania as a whole, African Americans make up 14% of the population, but they account for 48.2% of the delinquent dispositions and nearly 38% of placements. Juvenile placements also vary enormously in quality, and some are very dangerous. We were reminded of this in the fall of 2016 when a 17-year-old housed at Wordsworth in West Philadelphia was killed when he was choked in an altercation with staff. And again in August of 2018 when a child at the Glen Mills School, a placement for delinquent youth in Delaware County, was badly beaten by staff. For too long, the system has demanded that children be held accountable for their behavior, while the adults in position of power failed to make sure that the programs we send them to are working for their benefit. Well, we kind of think everybody should be accountable. For too long, these same adults in positions of power have agreed to send children to placements where they would never agree to send their own children or grandchildren. It has become increasingly clear that we do a disservice to children who are not dangerous to the community when we send them far away from their homes. Other jurisdictions, including New York, have implemented close-to-home policies which allow more kids to stay in their homes, or if they must be removed from community for community safety, to stay in the same school district or neighborhood. The results are impressive. High school graduation rates are better, rates of recidivism are better, and youth and family satisfaction are better, and it all costs a lot less, which allows us to reinvest that money into things that work and into the, frankly, thin group of possible alternatives. We encourage our system partners to embrace this model. There is a category of children accused of committing crimes who are not addressed in these policies, but they are addressed in the decisions that are made in this office every day and have been made for a year. And those are children who must be charged as adults under Pennsylvania law because it is required by Pennsylvania law. They are known as direct files. In other words, juveniles who by statute must have their case directly filed into adult court. These obviously tend to be more serious felonies. They stand accused of serious felonies where a deadly weapon was used. While these children must initially be charged in adult court, this office has the discretion selectively to send cases back to the juvenile system. So let me tell you what it looks like comparing 2017 to this administration, which started in 2018. In 2017, there were 210 direct file juvenile arrests, and because of the policies of that administration, 128 cases were returned to juvenile court, which is about 60%. So they'd start in adult court, but about 60% would make their way back to juvenile court, and that was with 210 arrests. This year, we have 147 arrests rather than 210, which is obviously a large reduction. And because of these policies, 124 of those 147 were returned to juvenile court. So we have an 85% rate of returning the smaller number of direct file cases to juvenile court, 85% rather than 60% the year before. I should also say, and this is a very important point, that that process in the prior administration often took months, with juveniles being held as if they were to be charged as adults. And now we are moving as quickly as possible. Often these decisions are made within days or at most a week. This is our current starting point, and now with the implementation of these new policies, we will try to make sure that it only gets better. Right now, there are under 10 males and 0 females, down from 40 children in adult custody on State Road, thanks to our new approach and mandate to keep juveniles out of the adult system. We have built and implemented these policies and reforms in a careful and thoughtful way with an eye toward the safety of the community and the best interest of the child, and we know now, and the U.S. Supreme Court precedent acknowledges this. This is what our conservative U.S. Supreme Court has to say. Children cannot be held accountable in the same way as adults because their brains have not fully developed all the way up until age 25. And that specifically means they are less culpable and they are more open to rehabilitation. It is unjust and unnecessary to punish children for their actions in the same way that we would adults. It's highly ineffective in terms of keeping the public safe. This office will continue to transfer children accused of serious crimes back to the juvenile system where it is appropriate and where it does not compromise public safety. In every unit within the office of the DA, we are striving to create fairer, more thoughtful and effective prosecutors. Our juvenile prosecutors are critical to this mission, and we hope that these policies and trainings that will accompany them can reshape not just this office, but the juvenile justice system in Philly and beyond. You should know that our juvenile attorneys have already had 4 trainings in these policies before we announced them here today. And now I would like to introduce 2 amazing young ladies, Bree and Lily. Bree is 21 and Lily is 16 years old. They both have powerful stories to tell about their own experience in juvenile placement, and they are both members of Juveniles for Justice, which is a juvenile law center project. Thank you for joining us here today. Would one of you care to go first? All right, Lily, please.
Good morning, everyone. Thank you for attending. My name is Lily, and I am 16 years old. I am a current youth advocate with Juveniles for Justice with Juveniles Law Center. I am a sophomore in high school. I have many plans for the future, including attending college for criminal justice, joining the SWAT team, and becoming a lawyer and advocate for youth, for foster youth. This is my 2nd year working as a youth advocate at Juvenile Law Center and a part of Achievement Independence Center. And I am getting support from my parents to stay active and seek out new hobbies. When I entered the delinquency system, I was only 13 years old. I am speaking here today to support the policy changes that would put fewer kids in juvenile placement. My mom thought going to a juvenile facility would be good for me. She thought I would be safe. She did not realize that I would be abused, strip searched, mistreated, or I wouldn't be able to continue my education. I hope that by me today sharing my story, parents and leaders will realize that youth are better off staying in their own homes. I am sharing some really hard things that happened to me because I don't want them to happen to any other youth. I first went into placement of May of 2016 and was in 2 different facilities for a total of about 7 months. There was a lot of physical abuse happening in the Philadelphia facility where I was first placed. There was 1 staff assigned to each floor. They felt like they could do whatever they wanted to do with the youth. Staff fought girls and male staff restrained female youth, which didn't make me feel right. Staff also let youth fight other youth by giving them permission to go off-site of the camera so they wouldn't be able to be seen. If I act out, they would put my hands behind my back and throw me on the floor. One time I refused to go to the main room and a staff body slammed me, then put me in a small room with just 1 staff person for about a whole day. The room was in a boys' hall and I had nothing to do in there. I had eaten around breakfast, but from 9 a.m. to 3:30 p.m., they didn't let me eat anything. Sometimes staff played favorites and other youth would get multiple snacks or meals while I went hungry. The food was also unsafe. I found worms in my food a couple of times. There was no school at the facility. We had to stay in 1 room all day. There was no teachers, no books. There was just a TV, and that wasn't even on, only if a staff wanted to watch TV. There was nothing to do in there, and I hated going there. One time, a staff member burnt me with a flat iron while she was straightening my hair. Afterwards, I was in a lot of pain and asked to see a nurse, but she wasn't there because she was only part-time. And I never had got to see a doctor until I went to court 4 or 5 days later. But that time, it was all scarred, and when my judge saw what happened to me, she moved me to a different floor. There are juvenile delinquent centers across Philadelphia and nearby where youth may be going through the same thing. It is hard for youth to speak up about these things. When I was in a facility, I was too scared to open up and talk. I didn't think anyone would believe me, and I didn't think anything would be done if I speaked up. Why should I think anyone will help me? Excuse me. Why should I think that anybody will help me as if they're sitting there harming me? Being in placement really messed things up for me. I tried to go back to the charter school that I attended for 2 years, but they didn't let me go back in. My only option was to do cyber program. I didn't learn anything while I was in placement, and to this day I'm still having trouble in school. I ended up having to take 8th grade classes like pre-algebra that I should already known. I now have trust issues with adults. Going to placement changed the way I was. I became quiet and didn't want to be around anyone else. When I got home for placement, I got all the love that I was missing for all those months. I wish I had to stay home with my family the whole time. I am speaking here for the youth that are in delinquent and child welfare centers and going through the same thing that I've been through. I want to make a change and support the policies that will put fewer youth in placement. Thank you for so much for listening.
Good morning, everyone. My name is Bree. I'm 21 years old. I want to go to school for cosmetology, and then when I was done, I wanted to start my training at the academy to be a firefighter. I was 17 when I was in a juvenile placement. I've been a member of Juveniles for Justice for 3 years. Juveniles for Justice is a youth advocacy program for youth with experience in the justice system through Juvenile Law Center. We recently wrote a report of our experiences called Broken Bridges, which we published and have here. My experience being locked up in 2 different facilities was horrible, especially when I was physically restrained for no reason after I followed basic instructions that a staff member gave to me. I felt uncomfortable and unsafe with male staff working on the unit where I was placed. When the male staff physically restrained me, he came up from behind, grabbed the back of my neck, and slammed me on my back. Not only did it hurt, but I have a spinal injury, and could not seek medical attention right away. He also used his knee to restrain me for 20 minutes. My chest started hurting after a while. Not only that, I have asthma. The whole time being restrained was scary because of both my medical conditions. This is why I recommend that male staff don't work on female units. I felt like this man was rough on us. At one of the facilities where I was held at, I was strip searched. I felt very uncomfortable and I felt violated, especially because it was in front of more than one person. They strip searched me without telling me why. It happened for about 15 to 20 minutes. Not only did they pat me down, but they took my clothes off for me. Being away from my family in the juvenile facility caused a lot of pain for me, and it was very hard, especially since I couldn't talk to my family every day like I wanted to. I felt lonely and depressed, even more worse than I was already. Overall, my experience in the system was not great, but I know from that experience that I can use my voice to make changes, not only for myself, but for other youth who are experiencing what I went through. I support policies that would make it so fewer kids are placed in juvenile detention. Being in placement did not help me, it hurt me. I don't know who in this room has children, but I would ask that you think about me as if I were your child. Would you support me in any way possible? I hope so. Thank you for inviting me and listening to me.
Thank you to Lily and Bree for sharing your stories with us today. And now I'd like to introduce First Assistant DA Robert Listenby, who, along with his team, was the driving force behind our new policies and the related reforms.
Thank you, DA Krasner. I also like to thank Lily and Bree for their statements today. Sometimes we forget, what's really happening to our children when they go into placement, and we have the good fortune today of having two young ladies come here and explain their personal experiences and how deeply those experiences impacted them in negative ways. District Attorney Larry Krasner was elected with a powerful vision and mandate to reform the policies of the Philadelphia District Attorney's Office as they apply to the juvenile justice system. From the very beginning, he insisted that his staff develop policies that treat kids like kids and not like small adults, and that focus on rehabilitation and second chances as opposed to punishment. He also insisted that we pay close attention to the needs and concerns of victims and witnesses that testify in juvenile proceedings, as well as the constitutional rights of children who are defendants in those same proceedings. In addition, he's required his staff to take into consideration the interests and concerns of communities where our children reside and listen to the concerns of community members. With these ideas in mind, I would like to talk about the 7 policies that we are sharing today. There are 3 very important principles that apply to each of the 7 policies. I will discuss them in detail as they apply to the first policy, but I won't discuss them as they apply to the other 6 policies, though it should be understood that they apply to each of those policies. You have copies of them so you can read how they apply. First, the policies are written as guidelines, or in legal terms as presumptions. They are to be applied in an individualized way to the facts, the law, and the circumstances of each case. They are not rigid dictates from District Attorney Krasner or his supervisors. Second, under District Attorney Krasner, each assistant district attorney is given the discretion within limits to decide how to handle his or her cases. And third, each of these policies comes with exceptions that limit their application to very serious cases. Let me go first to the first policy on juvenile pre-adjudicatory offers. This policy is designed to increase diversions, the number of children who stay out of the juvenile justice system. Here, we offer deferred adjudications in most cases. Children are placed under court supervision for a period of time without an adjudication of delinquency, which is the juvenile equivalent of an adult conviction. If a child complies with the terms of the deferred, the case will be dismissed and the record can be expunged. So, we're trying to divert more cases with policy number 1. I want to go over the exceptions because these apply to many of the other policies, but in different ways. There are several exceptions which I want to focus on. First, A deferred may not be appropriate if a child has a prior adjudication of delinquency, is charged with a possession of a gun, is charged with aggravated assault and has intentionally inflicted significant or serious bodily injury on the victim, where the youth is charged with rape, sexual assault, involuntary deviant sexual intercourse, or aggravated indecent assault, where the youth is charged with a felony of the first degree where a weapon is used, or where the youth is charged with invasion of a home of another with a weapon. So the policy don't apply to those specific exceptions. Where a deferred is inappropriate, a reporting consent decree, which is a 6-month supervision, can be made available with the expectation that an expungement can occur 6 months after a child is discharged from court supervision. Under the current rules, children have to wait for 5 years after discharge from court supervision before records can be expunged. So we're trying to, kids who come into the system, we'd like them to get out and not have them permanently stigmatized or stigmatized from 5 years, barred from getting certain kinds of jobs or achieving certain kinds of educational goals. Policy number 2 focuses on juvenile reporting consent decrees and extends the offer of a consent decree to all cases where there is a misdemeanor as the lead charge. Once again, children charged with misdemeanors, we want to get them out of the system, so we want to give them consent decrees. According to research on juvenile probation, there should be no more than 3 conditions imposed on a child who's on probation. What we find under current practices is that many of our children are given 3, 4, 5, 6 conditions. What is that? That's the prescription for failure. How can a child complete all the different conditions placed on them and at the same time go to school successfully, and many of them are working? So we want to restrict the number of conditions to 3 for almost all the times that our children are placed on probation. Finally, children placed on reporting consent decrees should not be required to complete more than 25 hours of community service. Again, if you have 100 hours of community service or 200 hours of community service, you don't have time to go to school, you don't have time to go to work, you don't have the time to take care of all the other kinds of obligations you have. Policy number 3, it is our goal to reduce the number of children held in detention. Why? Because we know that once a child is held in detention, the likelihood of going deeper into a system is pretty well established. So we are recommending that all of our assistant district attorneys, or we're requiring them to recommend alternatives to detention where children are arrested, where they have bench warrant hearings or violation of probation hearings. Once again, this policy is crafted with several specific exceptions designed to communicate with victims and protect the public. Policy number 4, under juvenile disposition is our juvenile disposition policy, where a child is found guilty of an offense and placed on probation. An assistant district attorney should ask for the least restrictive community supervision program available, and again, with no more than 3 conditions of probation. If the court commits a child to a residential placement, an assistant district attorney should recommend the closest placement facility that meets the needs of a child. We want them closer to home. We want them to be able to meet with their families. We want them to be able to have families engage with them while they're in placement. Also, we are no longer recommending specific lengths of time when kids are going to placement. Assistant district attorneys should also not recommend that a child found guilty of committing a misdemeanor offense be sent to placement, except with permission of a supervisor. Also, an assistant district attorney may not recommend that a child under the age of 14 be sent to placement without the permission of a supervisor. Why? Because most children who are very young should receive appropriate community-based treatment, not be sent 200-300 miles away from home and thereby causing greater problems for them to adjust when they return back to their families. Also, no child should be sent to placement that cannot meet his or her educational needs. Many of our children who are going into placements have individual education plans. They go to places where those individual education plans cannot be met. They come back, they have to start all over. Many of our kids go to placement, they come back, they don't get credit for the time they were in school and in other placements. So they really have to start all over, as we heard from one of our young people who was speaking here earlier. Our policy on juvenile review hearings. Residential placements should only be sought if 6 listed community interventions have proved ineffective or impossible. So we're giving our assistant district attorney 6 alternatives before you get to the point of looking at placements. Residential placements should not be sought for youth who've been found guilty of 2 or fewer misdemeanors. So you've got to get a couple of misdemeanors before we think you should even be considered for placement. We do not want our kids to go into placement unless it's absolutely necessary. Probation violations such as missing curfew, failing to attend school, and the use of marijuana should be treated with community programming. Children should never be placed in a residential facility for failing to pay restitution or court fees. Our kids are basically being sent to debtor prison to pay for court fees and restitution when adults can't be sent there, and we don't think that's appropriate for our children. Policy number 6, the use of solitary confinement. The District Attorney's Office strongly opposes the use of solitary confinement. Keeping children in isolation can have long-lasting and devastating consequences on youth, including trauma, psychosis, depression, anxiety, and an increased likelihood of self-harm. There's absolutely no research suggesting that solitary confinement is an effective means of controlling the behavior of young people in custody, and yet isolation is not uncommon, particularly for those youth held in adult facilities. The District Attorney's Office urges the Philadelphia Department of Prisons to rethink its policy on juvenile solitary confinement and to train its staff in alternative methods of discipline. We ask that our juvenile justice partners monitor the placements when we send children, Philadelphia children, to ensure that these methods are never used on our children. And final policy is the juvenile bench warrant policy. Assistant district attorneys should oppose the imposition of these kind of bench warrant sort of provisions. Bench warrant hold, bench warrant do not release, judge only bench warrant, or bench warrant hold do not release, commit to placement upon apprehension. Why? Because these kinds of bench warrants violate the constitutional imperatives that children have. If you have a bench warrant and you're brought back in, the reason you didn't appear was because your parents didn't give you the money to get on the bus to come, or your parents held you out and didn't bring you down to court. Why should you be sent away for placement when something like that happens? That kind of thing is happening to our kids. We also know that when kids come in on bench warrants, what happens is, if it's a bench warrant hold, do not release, kids are held in our detention center for 7 to 10 days, usually 10 days, until they can appear before a judge. The average cost for holding a child in the detention center is somewhere between $600 and $700 a day. Why should we hold a child in our detention center for that length of time when if you brought them before a judge immediately the same day or the next day, the issues could be resolved and they could go forward and with whatever appropriate judgment the judge decides. Finally, if you look at bench warrant hold, do not release, commit to placement upon apprehension, that is totally absurd. You have a child who didn't get into to court because the parents didn't provide funding. The child is held and committed to placement that will cost $150,000 to $200,000 a year per child. And for what? Because they didn't get to court and it was beyond their control to get there? Those kinds of policies should be eliminated in family court. In conclusion, I'd like to make a few comments that really recognize something that people really need to understand. There have been significant achievements by the stakeholders here in our juvenile justice system. As DA Krasner pointed out, the number of petitions has declined from 10,000 to 2,400 between 2001 and 2018. Also, the number of placements has declined from 976 to 516, or 47% between 2013 and 2018. In spite of this progress, if you ask the citizens of Philadelphia if they would be confident if their children or grandchildren entered the juvenile justice system, that your children would come out better at the end than they were at the beginning, I think you get a resounding no. I've asked judges and defense attorneys, prosecutors, all across this nation, if they felt that they had confidence in our juvenile justice system, and very few do. So if that's the case, why are we sending everybody else's children but not our own into these systems? We have to correct them and make them safe for our people. As far as education is concerned, if only 36% of our kids are actually graduating from high school after we send them to these very expensive placements, perhaps we need to rethink the system altogether. As Philadelphians, we've watched with great admiration as New York City has adopted and refined the close-to-home model and returned over 500 children from out-of-home placement facilities across the vast state of New York to New York City. Several of our leaders have already visited these programs. Many of us are also aware of the important work done in Pittsburgh, where the family court has adopted an entire trauma-informed court model to address the needs of its children. In 2017, Judge Kim Berkeley Clark, administrative judge of Allegheny's Family Court, who developed the trauma-informed family court model, was recognized as one of the top judges in the entire nation by Chief Justice Roberts of the United States Supreme Court. As Philadelphians, we will seek to find our path to greatness, borrowing from other models and adopting them to our own unique needs. But our children can no longer wait for the perfect solution as they pass from adolescence into young adulthood. District Attorney Krasner's vision and mandate have given those of us in the District Attorney's Office the opportunity to exercise our discretion to improve the lives of our children by making recommendations to the stakeholders in this system. We are hopeful that many of them will join us in support of these recommendations. Thank you.
Thank you, Bob. And now I would like to introduce Councilwoman Helen Ginn, a great partner and fighter for juvenile justice here in Philadelphia.
Thank you very much. So today is for Lily and Bree and every young person who had the courage to step forward and share their stories. Today is for every parent, grandparent, and guardian who challenged a system that they knew was wrong, who took on the school districts, the placement centers, the courts, and even the district attorney's office to know that their children demanded better. And today is for every legal advocate, every juvenile justice advocate, every young person educator who's fighting for young people who are trying to reform a system. And in other words, today is a long time coming. It's been a long time coming. It's about acknowledging that the incarceration of children is a poor substitute for giving them the actual supports that they need, or assuring victims and the broader public that young people are in a place where they can truly heal, atone, and grow. And instead of, as has been said before, the amount of money we're spending on this is staggering. We spend over $100 million a year on the city side, an additional $50 to $60 million a year on the school district side, money that could pay for an army of counselors, that could pay for restorative justice programs or art therapy in schools, is instead going to many places that have been labeled by the Children's Rights and the Education Law Center as places that are highly restrictive, undermine academic progress, and set vulnerable children on a path to homelessness, unemployment, and incarceration. That's not a solution. I've also spent a lot of time taking a look at who's actually watching over these facilities. And what we know is that there's almost no oversight. The State Department of Education does not have appropriate oversight. The State Department of Human Services does not have appropriate oversight. So what that means is the solutions start here at home. And that's why I've been incredibly proud and grateful to District Attorney Krasner, to so many of the organizations in this room, that we've been able to get at some of the root of what's harming young people. If we're going to refuse to look at why a student is truant, how that young person's school is underfunded, or how to support a young person's family when they are crying out for help, we're not going to get there. Today's announcement aligns with the work of the Youth Placement Task Force. I'm so honored to have members. I want to acknowledge Councilman Kenyatta Johnson, who was a partner in the creation of this, but also a wonderful partner in all my work, Councilwoman Janie Blackwell, and members of the Committee on Children and Youth, as well as some of my organizational partners, Shakima Townsend Moore, who's here from Philadelphia Youth Networks, Leola and Ellen from the Defenders Association, Juvenile Law Center, and so many others. But the work of the Youth Placement Task Force was formed in June, and its purpose is to align city agencies, including the Managing Director's Office, DHS, Department of Behavioral Health, CBH, and our nonprofit partners to all come together to find a way to bring our young people closer to home. I want to say that all of our work is driven by the voices of young people themselves, including Lily, who spoke at a recent city council hearing. But whether they did it in front of city council or whether they did it in a camera in their own rooms, we need to know that those changes are driven by and our solutions are going to be driven by those young people. And today is a critical step in taking a big step forward in ending that school-to-prison pipeline, forcing us to recognize that we're not going to arrest our way out of solving our problems. Jailing young people must be the last resort. Placements for young people must be a last resort. And District Attorney Krasner's guidance should urge all of us that collectively we can recognize that a less punitive path is possible. And we're going to do great things for our young people in Philadelphia. Thank you.
Thank you, Councilwoman Ginn. As our final speaker in just a moment, I'm going to call up Marcia Levick, but I do want to say one thing about these two council people and so many others in the council. When you see a council person who keeps sticking up for people who can't vote, that tells you something. When they're sticking up for homeless people, undocumented immigrants, and children, that should tell you something. And now, I would like to introduce Marcia Levick, who is the Chief Legal Officer and co-founder of the Juvenile Law Center. Marcia is an important ally and was instrumental in making sure that these policies were correct and that we addressed the right issues in the right way.
Good morning. Let me note, first of all, that D.A. Krasner is the first district attorney who has ever invited me to his table. And I want to say not just to sit across from him, but to sit by his side as a partner. And that is no small statement about how far we have come in Philadelphia. I don't want to repeat what's been said. I'll say ditto, ditto, ditto. But there are a couple of points that I do want to make. One is that many of you probably don't know that 2019 is the 120th anniversary of the juvenile justice system in this country. The first court was created in Chicago in 1899. The idea behind that system, believe it or not, was actually about rehabilitation. It reflected the notion, albeit not in scientific terms, that kids were different and that kids were entitled to both a second chance and were entitled to be really prevented from experiencing the consequences of a criminal conviction and a felony record or even a misdemeanor record. And in an interesting sort of way, as we think about where we are 120 years later, the kind of policies that have been announced today that D.A. Krasner and his team, and I want to acknowledge Bob Listonby and Dana Bazelon for their work in putting these policies together, as well as our many other partners across the city, that these policies in many ways are, I think, an attempt to frankly bring us back to first principles. There's first principles about rehabilitation, about second chances, about believing in kids. I also want to acknowledge the voices of Bree and Lily. I know them because of their work with Juvenile Law Center, but I want to be clear that it's not just their courage that we need to applaud here. We need to listen. The fact that they are willing to speak about their experiences in the system is really a call to us that we must listen, we must hear, and we must do better by them and by their peers and by the kids who will come after them. The thing that's most important about the policies that have been announced today is that they are effective and rational, they are research tested, they are financially sound, they respect and reflect the dignity and humanity of our children. They respect victims, and they will promote public safety. I would ask all of you here, what more do we want from a juvenile justice system than to check off all of those boxes? The last point that I would make is I'm going to sort of put out a call there to D.A. Krasner and his team. We did work on these policies, and we are really grateful. I see this as a first start. And what I mean by that is that I think that the real message of the juvenile justice system in this country today, and I see this all around the country in the work that we do, is that we have really shifted our focus in thinking about kids away from their crimes and thinking about who they are. And so one of the important aspects of these policies in their first iteration is that we are focusing on kids who commit misdemeanors, kids who should never be in the juvenile justice system at all, truancy, technical probation violations, things that don't warrant our criminalizing this conduct. This is conduct that we can treat in our homes, in our schools, and in our communities. But don't forget about the kids who do commit more serious offenses, because the reality is that when I say that these policies are research tested, that we know that they will be effective, that we know what works, it's every bit as true for those kids who commit serious crimes as well. And I don't want to abandon them. I think we have seen in the remarkable progress we have made on behalf of youth who served mandatory life without parole sentences for homicides that they were convicted of as children, as more than 150 of them have come home into our communities. They are living safely, they are living productively, they have been reintegrated effectively into their communities, and I want our kids who commit serious crimes back in our communities as well. Thank you.
Thank you for that, Marcia. I'd also like to recognize Public Defender Keir Bradford Gray, who's over here, who has been a great partner in these reforms, as well as many others. We thank you all for joining us today. We are now happy to take questions about these policies and reforms, which we want to bring to the Philadelphia juvenile justice system. Understand, though, the experts are behind me, and they are out here. Yes, I've been in criminal justice for 30 years, but I'm getting way too much credit for people whose life's work and whose expertise has been in juvenile justice. So I hope that you will consider getting the real information from the real source. Are there any questions?
Do you think racial prejudice plays a role in the failure of this system in that so many kids of color are in it and you elect mistreatment?
My answer is yes, but I would like to ask Mr. Listenby to say more than yes.
I think the answer is yes as well. And as a person who's worked on racial and ethnic disparities with the Pennsylvania Commission on Crime and Delinquency since 2001, 2002, this problem has been almost intractable. And it's time that we really come up with some serious solutions to address the problems. When former Deputy Commissioner Kevin Bethel's program went into effect, and he reduced the number of kids going to the juvenile justice system from 1,500 a year to 500 a year, thereby removing 1,000 kids from the system. That had an actual impact numerically on the racial disparities of Philadelphia County. It reduced it slightly. We need other major impacts from policies to reduce the number of kids who are going into the criminal justice system, the juvenile justice system, from our schools, and also through the other areas in which they go into the system here in Philadelphia.
Are there more questions?
Do you have enough resources to handle kids who are not being placed? Are there resources out in the community to handle these kids?
There are not enough resources, and needless to say, the district attorney's budget is a grain of sand compared to the city's budget. We have to be willing to take the savings that we are achieving with these modern policies and reinvest that money into things that work. We were speaking earlier, in fact, I was speaking to I forget your exact title, to Christina Bradley, who I've known for a mere 29 and a half years, who has been doing social work involving juveniles for, if not her whole career, then almost her whole career, about the reality that there are often situations where both the assistant DA and the public defender want some type of placement or treatment or assistance or program that doesn't exist. Well, we need to take the approximately $15.4 million that have been saved simply by reducing placements by 88 juveniles. And we need to put that into stuff that actually works. And when we start doing that, then we are going to see the blossoming of alternatives to this overly carceral system. Are there,
Mention something.
sure.
So in June, the City Council of Philadelphia created the Youth Placement Task Force, which is a closer to home initiative. It brings together a multitude of different agencies, nonprofit partners. The purpose of the task force is to come up with a series of recommendations to reduce the number of young people in placement. So roughly 2/3 come out of the juvenile delinquency system, 1/3 come out of the dependent system. Certainly we do not want to see young people who do not have homes be in placement. That does not make any sense at all, so we're trying to reduce those, and in return we're working to build closer to home alternatives that include smaller facilities and sites that are within the boundaries of the city or extremely close to them, certainly having higher standards and regulations, taking care of the education component. There's a lot to do, but we expect that we'll shoot to have a number of those recommendations in June.
Councilwoman or Councilman Green will select one for you. What is the role of the lawmakers of the city council in holding the institutions accountable, not just mitigating the amount of people who go in there? If these institutions are as bad as they're described, and I know they are, and I know there's also issues with the coolers and them constantly failing, where is the investigation? Where's the punishment? Where's the withholding of funds?
So I don't know that we can answer all of those questions. Certainly we have been loud about what happened at Wordsworth. City Council was extremely loud. We sent them a letter. It resulted in the closure of Wordsworth and the removal of the contract by the City of Philadelphia. We were loud about Glen Mills. We remain seriously concerned about an institution that's frequently known as being a quote-unquote hands-on kind of placement facility. We'll continue to work with DHS and others. We have control to close intake. Unfortunately, one of the problems that we've got is that there are multiple entities that do oversight on these agencies. So they're independently licensed by the state, so we can't remove licensure. We can decide whether we open or close intake. When we do, we have to think about the safety of the young people, not only who are already there, and whether we remove them from those facilities and then seek other alternatives. But I think that the concern, I think it was said earlier today that we are hearing regular complaints from individuals about violence, including sexual violence that is happening in these facilities, abusive practices. We still don't have a statewide prohibition on physical restraints, for example, which I think needs to happen immediately. But until we do, we have to, part of the work of the task force is unpacking all the stuff that we have the control to do, and then start to go out and enforce it. We're going to do our best, and we're going to take certainly closure, our intake capacity, and the use of contracts very seriously.
I would just add that everybody here has a responsibility, and the folks who are represented here, City Council, the District Attorney's Office, public defenders, youth advocates, there are other people who aren't here, juvenile court judges, who have a primary responsibility and authority, frankly, to place children in facilities, and they can undermine what's happening here today. We want them at the table as well. I know that there are ongoing conversations with them. The school district, community leaders, everyone who touches the life of a child needs to listen, needs to hear what's been said here today, needs to pay attention to the policies that have been proposed here. Unless we're all doing this together, this will not be an effective rollout.
Mr. Krasner, just a quick follow-up on what the council would say. The sexual assault, the violence that are happening in these institutions, does it amount to criminal activity? And if so, is the DA open to prosecuting some of the people who've been put to safeguard these kids? Because, are we talking about serious crimes here?
I will not comment on a particular allegation, but I will say absolutely we're open to prosecuting violent and sexually damaging crimes. We're open to that in any context with any vulnerable population.
So in the past, one way that the reduction of drug files in adult jails happened was through sort of coercive plea deals. Some would say where, it's like, okay, well, you look maybe the juvenile court if you agree with the plea. Is that kind of still going on in your industry?
Well, I would like to think that there are no coercive plea deals going on. I think that the reality is that I cannot speak to every single conversation that has occurred between our prosecutors who have discretion, but no, it is not a tactic to try to use coercive plea deals and use as an incentive in those coercive plea deals to move cases back to juvenile court. We had some, very deep and complex conversations with Paul Goldman, who is in charge of making these decisions and has been doing a great job, albeit a great job consistent with a different administration, for a very long time. And what is coming out of his decisions and his decision-making, along with supervisors, is a different approach that is trying, where it makes sense, it's trying to keep people out of adult jails and trying to keep people in juvenile court, where the focus is on rehabilitation, which, to be honest, is what the focus should be in both juvenile and adult court.
So are more cases being decertified without deals then, or are they still happening mostly with deals?
It's tough to say with or without deals, because most cases resolve as a deal. That is just the reality. A fairly small number of cases either resolves as a trial in the juvenile system, or a waiver trial, or a jury trial in the adult system. So there are deals, and I don't want to be misleading about that. If you want us to try to dig in and get statistics on it, we can do that, but I can tell you that this is an administration that, both for adults and juveniles, views the trial tax as being improper, that you shouldn't punish people for merely asserting their constitutional right to try a case.
I think during your campaign, it wasn't maybe an issue you brought up, but when asked, you agreed that you thought juveniles should not be held in adult jail. Is that something you still feel? Is that something you're still working on?
Well, yes, it is something that we still feel. In fact, the statistics on that are that when we came into office, there were 43 juveniles who were held in adult custody, and there are, as of today, 10. So I think that a reduction of 33, obviously you're looking at almost a 75% reduction, something like that. I think that speaks volumes about the individual justice that we're doing and how careful and selective we are about looking to see which juveniles can be returned. There's kind of a funny little anecdote here, which is at a church in Philadelphia, where the Reverend Damon Jones, as pastor, has been going up to this unit for years, and they've been going up to play basketball weekly with members of their congregation on the one side, and then with the juveniles who are housed in adult custody on the other side. Some of the kids play, and some of the kids are refs, and some of the kids are scorekeeper. Well, they're getting to the point where they don't have enough people up in county to do it. They're running out of people. And that's good. And it's not only good for the reasons I think we all understand, but it's good because even our federal government has said that holding them there will be illegal nationally within 18 months. So we're trying to lead rather than follow. We're trying not just to meet that deadline, but be well ahead of that deadline, and we look forward to working with other partners in that regard.
You feel that to do that, they'll have to be housed separate from the other juveniles?
You know, I don't want to get quite that granular. I'm sure you're aware of the discussions about whether it is more constructive or less constructive to mix people. There's a lot of data in general that tends to show that people charged with minor offenses do not need to be in close quarters with people charged with much more serious offenses. So those discussions are in play, and I also don't want to speak for the court system and other players in that, but certainly it is a concern that we get that issue right. Are there any other questions for any of these remarkable experts behind me? All right. Well, thank you very much for attending, and if there are questions on other topics, then I'll be available for some of that after this conference. Thank you.
Good job. That was excellent. And I